It's your boy Shots back in another video. Today we got another Melly, YNW Melly double murder trial. Like I said, this been fucking how long? February 2019. This shit has been going on for too long. Y'all might as well let him go. But according to now, we have a new document by Cup Boys. Shout out to Cup Boys, you know what I'm saying? But if we being real, can y'all just let this nigga go? If y'all can't find this nigga guilty, which has been 40 mistrials at least, bro, let him go, bro. What do we think of what he is? I'm not saying it, but you know what I'm saying?
We are now a year removed from the first YNW Melly double murder trial that ended in a hung jury. Melly's retrial was paused after the state appealed a judge's ruling that excluded evidence from Melly's phone records, emails, and social media posts. Alright boys, I know this trial's been crooked for months, but today I'm going to read a few documents, and Melly's former lawyer, Bradford Cohen, a very seasoned lawyer from Florida, posted a new document on Instagram today, and I'm going to read that because it's really interesting. Hit subscribe, like the video right now, let's get right into it, boys. Alright, so the first document we got here is order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. So when the state requests...
Put him on house arrest, bro. Like, I ain't gonna lie, just put this nigga on house arrest, dude. Put him on house arrest.
Said to stay on this case, they wanted it completely paused while the appellate court dealt with everything else. Melly's team wanted to proceed to get it going faster. The court cites this case right here, says the taking of depositions is not a judicial proceeding since the judge is not in attendance and since the deposition cannot be received in evidence. From 1985 and 1987, if depositions are not judicial proceedings, it stands to reason that no part of the discovery process can be a judicial proceeding. The state argues that the automatic stay provision divests this court of jurisdiction, and the 4th District Court of Appeal now has sole jurisdiction of the entire case. This is incorrect. They're saying the state is wrong. The court retains jurisdiction over discovery matters as well as all matters collateral to the subject matters on appeal, even though the case has been automatically stayed. While this court denies the vacator of the automatic stay, the preceding analysis is helpful in determining whether to partially modify the stay to allow for discovery and litigation related to discovery issues to proceed while the orders on appeal are pending before the 4th District Court of Appeals. The court finds that there are compelling circumstances to modify the stay to allow for discovery and discovery related litigation to proceed while the rest of the case is stayed. So it sounds like the judge has a brain and wants this trial to be fucking over because it's 5 years. Holy shit, this guy's been locked up for 5 years.
That's what I'm saying,
if the defendant is unable to proceed with discovery, he will be forced to choose between his speedy trial rights and his right to a fair trial when the 4th District Court of Appeal eventually issues a mandate in this case. Since he is not...
Bro, if they keep this trial going to like 2030, nigga, and this case came out when I was like, what, 8th grade? Bro, let this nigga go already, bro. Like, I'm getting tired of this shit, like, for real, bro.
Entitled to a pretrial release, he will be detained for longer than necessary pretrial due to the delay in concluding discovery. Both cases involve complex issues, expert testimony, multiple witnesses, and extensive discovery. While the state continues to obtain evidence and conduct additional testing during the pendency of the appeal, it is highly unlikely that the defendant will be able to dispose all witnesses and fully prepare for trial within 90-day speedy trial window that starts to run after the 4th District of Appeal issues.
So pretty much, y'all, and then I get hit with an ad. So pretty much, they're pushing this nigga shit back every 90 days. Just let this nigga go already, bro. I'm tired of this shit already. Because, like, every time we hop on Instagram, it's either Melly trial, Melly retrial, Melly this, Melly that. Bro, let this nigga go on house arrest, bro. It's been fucking 5 years, and y'all can't even decide the nigga guilty or not.
Mandate of discovery does not proceed during the pendency of the appeal. Not only are there other outstanding depositions of expert state witnesses, but the defendant may need to retain his own experts based on the outstanding discovery and the depositions of the expert witnesses. The co-defendants will be forced to face the same Hobson's choice. Proceeding with discovery and depositions and litigating discovery-related matters will in no way affect the issues that are currently on appeal. Okay, so that last sentence right there sums it up. Let's get this going while the appeal is being handled. The judge had a brain. This was filed May 2nd, so I haven't made an update video since April. My bad. I've been consumed by the YSL trial. All right, here we have another motion to compel discovery. On February 7th, 2024, defendant filed his motion to compel discovery regarding the below. Proof of all efforts made by all law enforcement agencies to serve Mariah Hamilton with writ to appear at trial, including but not limited to skip traces, searches for employer, searches for enrollment in college, trade schools or other educational institutions. All efforts by and between the state attorney's office and Christopher Barras to amicably resolve his issues of Mariah Hamilton giving a statement. On February 9th, the court entered an order granting the defendant's motion. Rather than provide the requested discovery or in the alternative response that the documents don't exist, the SOF filed a motion for rehearing which was denied. A week later, to date, the SOF has not complied with the discovery request. The SOF is willingly disobeying the court's orders and should be held to answer as to why they won't provide the corpus delicti of the witness tampering charge. Damn, so they're straight up ignoring the court's orders in regards to the witness tampering. The state's been very grimy in this case. I'm going to be honest, boys. The detective was sketchy. Remember, the detective was proven to be a liar. A member of the district attorney's office even said that he was a liar, like his own side straight up said he was. The actions of the SOF are in bad faith, and defendant requests that if the above described discovery request is not provided, then the information filed by the SOF should be dismissed. So now here's the state's response to the defense's second motion to compel about what I just read before. They say the state was never notified for this motion to be heard on February 9th. On February 6th, the state emailed the Honorable Court confirming the motions that was believed to be set for this particular hearing date. These motions include the defense urgent motion for status. At no point in time was the defense second motion to compel ever docketed to be heard. Despite not being placed on the docket for hearing, counsel for the defendant presented the motion in court. When this motion was brought up by defense counsel, the state very clearly stated that this motion was not set for today, and that the state would like time to respond to this motion in writing. The court, without any indication of response.
Y'all want to know one thing I do not like about this shit and I do at the same time? Y'all niggas want to make so many documents about some bullshit that we already know, kind of, because it's like, y'all been doing this shit since February 2019. Then again, just let this nigga go. It's not that hard. It's been 5 years. They already said if it's been like 7 mistrials, y'all should already let this nigga go. It's been like at least 20 of them last time we checked. Just let him go. Guilty or not, shit. Y'all would have been found this nigga guilty already if it was not like the second mistrial. It only takes 3 mistrials, but I don't know if I'm correct on that one, but like for real, like everybody that's in the comments and shit, y'all getting tired of this shit. Am I lying? Like we're getting tired of this shit. Like
simply said, what's next? Wait, so the state's saying this wasn't planned at all and everyone just wanted to proceed? God forbid the defense and the judge say, what?
Melly sue, go ahead and start suing. They just wasting this nigga Melly time, bro. Like,
What's next? Let's keep it going. I know they have to keep it in order and everything and have shit on the docket, but God forbid they speed up shit. The state was not noticed nor given a proper opportunity to respond to the defense motion, yet the court issued an order. The court issued a written ruling granting the defense motion without giving the state a reasonable nor meaningful opportunity to be heard, which has violated the state's due process rights. Had the state been given a meaningful opportunity to be heard, the state would have made the following points of law and fact. Here we go. Here's the response. Due to the inherent nature of the charge of witness tampering, discovery from the defense's original case is relevant to the defense's newest charges. The defendant moved to depose Christine Bradley, who was the assistant state attorney that was in Melly's first trial, the brunette girl. The state objected, and this honorable court specifically asked the defense counsel why they wanted to depose her. The defendant's counsel made baseless, unfounded accusations of Bradley, accusing her of not making any efforts to bring in witness Mariah Hamilton for deposition. The defense counsel further stated before this court that they specifically wanted to depose Bradley regarding her alleged efforts in bringing in witness Mariah Hamilton for deposition. The state responded in open court saying there are emails to prove what counsel is saying is unfounded and that the state is currently going through all of them prior to sending them out in supplemental discovery. This honorable court deferred ruling on the defense request to depose Bradley and ordered state supplemental discovery December 28th. Melly's team had big accusations with Christine Bradley about not putting effort and having Melly's ex-girlfriend to come in for a deposition. State is saying this is complete cap. To dumb that down, these emails indicate there were times Miss Hamilton's counsel was unresponsive and Bradley had an investigator assigned to make sure he was okay. In fact, leading up to days before the deposition, Bradley even contacted Miss Felicia Holmes, Miss Hamilton's mother, due to unresponsiveness of her counsel. She also contacted other individuals that worked with counsel to try and get a hold of him. She also contacted other people. The emails prove that no one was getting a hold of anybody. Proof of all efforts made by all law enforcement agencies to serve Mariah Hamilton with writ to appear at trial. This is impossible to comply with. The state is not privy to what police departments in other counties do in order to locate Miss Hamilton. Now they're citing some cases here. Despite the violation of its due process rights, and despite the defendant accusing the state of willfully disobeying a court order, the state has turned over what it can turn over prior to any order from this court as laid out above. At this junction, the defendant's motion is repetitive, frivolous, and an abuse of the court's time, therefore should be stricken. Alright, so the state is not happy. I'm telling you, man, Melly's team got rid of Christine Bradley, the first assistant state attorney. The new one, the blonde Alexandra Buckaloo, is no joke. Like, she does not play games. Might have shot themselves in the foot there. All right, another document, second amended sworn motion to dismiss. They got the dates wrong. On October 17, 2023, the defendant was charged by information which includes, but is not limited to, tampering of a witness in capital felony. Remember, Melly is accused of sliding in.
Like, why do I keep getting hit with this shit? Like, I'm just sitting here, like,
note under his jail door to someone else on the phone who then relayed a message to his girl saying, keep ASAP Rocky's baby.
Bro, I ain't gonna lie. Listen. I'm gonna just say this. Before, y'all was like, this was a fucking waste of time. Because y'all sitting here thinking about shout out to Cup Boys and shit like that. But, wait, what the fuck? Shout out to Cup Boys and shit, right? But if we being real, bro, this whole document, this mistrial shit that's been going on since 2019 has been a waste of time for Melly and all of us, cause we've been wanting this nigga to get out. Um, Sit here and really think about it, y'all, cause it's like, let's go ahead and do this. Like, I'm really getting tired of this shit. I ain't gonna lie. Like, this shit has been, yeah. I'm just gonna pull up one picture. This is all I gotta say. I'm not saying nothing else. Do y'all think he's guilty? I'm not saying anything, and nor I gave a fuck. But do y'all think he's guilty? That's all I'm gonna say. Put this nigga back on house arrest. Yes or no? It don't even matter. That nigga might pull a Boosie. You see what Boosie did? He got a murder charge and beat that shit, and then you know what I'm saying. But like I said, it's a waste of time out, bro. This shit was it's a waste of time.